Court rise.
Hearing in the appeal, Nadine against the Minister for Housing, the Government of Gibraltar and the Housing Allocation Committee.
Yes, Mr. Singh.
My lords, my lady, I appear for the appellant with Karen Monahan, QC, Professor Nadine and John Restano, and my learned friends James Niche, QC, and Michael Yamas appear for the respondent. This morning I have had handed up a short outline of my submissions, which I think will be underneath your notebooks, and I hope that this will save at least some note-taking and may provide a guide to where I shall be going in my oral submissions by reference to some of the principal authorities.
That's very helpful because we haven't got a great deal of time for what's a rather important case.
Indeed, I understand that, my lord. Lord, so may I just go through that outline first to see the signposts of where I intend to go. First, this case arises under the Constitution of Gibraltar, not the European Convention on Human Rights. There are two important connections between the Constitution and the ECHR. First, the grounds of discrimination in section 14(3) of the Constitution include such grounds as the European Court of Human Rights has recognised, and it is common ground between us that sexual orientation is one such ground. Secondly, account must be taken of the ECHR jurisprudence under section 18(8) of the Constitution. Next, we submit, however, such account does not mean that the ECHR case law is binding or even authoritative, especially since, first, section 14 of the Constitution is unlike Article 14 of the ECHR in that it is freestanding, although we also make the observation that if we're wrong about that, the appellant can invoke section 14 even if that were not the case, since the facts fall within the ambit of another right of the Constitution. At least, I think it's common ground, we fall within the ambit of section 7, which concerns privacy of the home.
Is it common ground that Article 14, that section 14 of the Constitution is freestanding?
No, that's not common.
No.
It is.
Oh, I'm sorry.
I think after Lord Novo, that's a very persuasive arbiter, I think would be very brave to try and argue out otherwise. In the case of St. Solomon.
In my own opinion, not speaking for any of my colleagues, that is a wise concession to make.
I believe I conceded that in the court.
I'm grateful to my learned friend.
But that is very helpful.
It's very helpful clarification. A second point we made under this topic is that there is no scope for the margin of appreciation because this is the Privy Council applying a domestic constitution, not an international court applying a treaty. Fourthly, we submit, in any event, the appellant's submissions are consistent with and supported by basic principles of the ECHR jurisprudence. Fifthly, we submit comparative case law on equivalent constitutional provisions, especially in South Africa, provide support for the appellant's submissions. Sixthly, discrimination can consist of either treating like cases differently or treating unlike cases in the same way. Seventhly, over the page we say that discrimination can consist of the impact on a group in effect, and not only because that is its purpose. Treatment may have a benign purpose and still have a discriminatory effect. Here, we submit, there is discrimination because same-sex couples are treated by the government's housing policy in the same way as unmarried heterosexual couples, even though the latter category have the legal opportunity to marry each other, whereas the former category do not. And there is no similar provision in Gibraltar, as there is, for example, in some countries, including the United Kingdom now, for civil union or partnership. May I, at this juncture, correct a typo? I'm afraid it was an important typo, and I apologise that it crept into our printed case. It's at paragraph 52 on page 20.
Yes, I put a question mark
The first sentence.
against the first sentence, which did not make sense to me.
Exactly, it doesn't make sense. I hope that in the context of the case as a whole, it was obvious that that's a typo, but can I correct it? And I apologise again. It should read, in the first sentence, as such, it is respectfully submitted that for the purposes of this case, that then should be unmarried, and one could insert the word heterosexual, so it would read unmarried heterosexual partners and unmarried same-sex partners are differently situated, and accordingly treating them in the same way is discriminatory. That is the burden of our submission in the printed case, and that is what I say in my oral submissions.
This is ground 2 of the grounds of appeal.
It is. Ninthly, in my outline, we say the discriminatory policy is not written down, it is not accessible or foreseeable, and does not constitute law. Therefore, the interference with Section 14 rights is not in accordance with law. The acting Chief Justice, Mr. Justice Dudley, was right in that respect, and there was no challenge to that finding. In any event, Sir Paul Kennedy in the Court of Appeal agreed with that. Discrimination on grounds of sexual orientation requires particularly serious reasons if it is to be justified, in accordance with the principle of proportionality. And at this juncture, I'm assuming that the respondents can get over the hurdle, the problem that it's not in accordance with law, but even if that is so, we submit that at 11 there is no objective justification which would satisfy the principle of proportionality, and we make 4 short points initially.
Just as an initial point, reaction to your paragraph 10, might not the respondent say, yes, but discrimination in favour of marriage requires scarcely any justification at all?
Yes, they might, my lady.
Yes.
And that's why I submit with respect that, for example, paragraph 7 of our outline is a very important element of our reasoning, which we commend to the Privy Council. I will go on to submit that it's powerfully supported as an analysis by the South African case law, which says that where there is a distinction in law between married couples and all others, that nevertheless that doesn't stop the inquiry. If the person before the court who's complaining of unfair treatment is a same-sex partner, then the fact that heterosexual partners who could marry are also treated in the same way as them, it is not an answer to justify the line being drawn at marriage. Moreover, we would respectfully submit, not only is it not part of the answer, it's part of the problem. That's what we say is the inherent discrimination in this case.
Just following up on what my lady said about your proposition 10.
Yes.
I would question whether this case is really about sexual orientation rather than the legal status of marriage. And because exactly the same answer would have been produced if these had been 2 sisters who had been living together as a household.
Well, that's right. But as I say, what we will submit is that when one analyses a discrimination argument, although the starting point will be where the law itself draws a line, that one can't stop there, that one has to examine what its impact is on possibly differently situated subgroups within the larger group which is excluded. And this is very much supported by the reasoning in South Africa, where the courts have said that it's the effect on same-sex partners which constitutes the discrimination, not necessarily leading to the same answer in respect of other subgroups. My Lord has put to me two sisters, for example. It may be that that's one such subgroup where there might not be unfair treatment.
It's your paragraph 8 is where you spell out the true discrimination.
My Lord, yes. Can I just conclude the outline then by going to the sub-points at 11? First, we say what has to be justified is the discrimination, not the underlying measure, which may well have a laudable purpose. Secondly, we do accept this, that support of the institution of marriage as such is a legitimate aim for a legal system. But what that then requires, we submit, is an important and rigorous scrutiny to be done of the means chosen. And our point 3 is that there is no rational connection between the means chosen and that aim. We pose the question, for example, how will discriminating against same-sex couples tend to make heterosexual couples more likely to marry? A point that my Lady Baroness Hale made, in particular in the Gaydam case, which I'll return to. And fourthly, we emphasise that the policy tends to place a greater strain on limited public resources because, as the board has probably seen from the factual background, what my client and her partner were advised to do was that the partner should apply in her own name. And so that would have the effect that there would be 2 flats taken from the public stock rather than 1, because they can't apply for a joint tenancy in the way that some people can. I hope that's helpful as an outline.
Yes, thank you.
May I turn now to the Housing Special Powers Act 1972, which is to be found in Volume 1 of the Authorities at Tab 2. And I will just highlight a few of these provisions because they're set out in the judgments below. First, Section 3 establishes the Housing Allocation Committee, and Schedule 1 is to have effect with respect to its functions, constitution and proceedings. In Schedule 1, I would invite attention to paragraph 2 in particular, that the committee shall administer any scheme on the allocation of government housing approved by the government, and when so required by the government, make such recommendations on the most equitable and effective use of government housing as the committee may think appropriate. Going back a few pages, there is Section 12, which does deal with the situation of where a tenant dies. Where a tenant has died, the housing manager shall, if the entitled person so requires and complies with the provisions of any rules governing the entering into such new agreement, enter into an agreement with the entitled person in respect of the premises on the same terms and conditions as the agreement with the deceased tenant, or such other terms and conditions as the committee may approve. And then to see the meaning of entitled person, one goes back to Section 2, the interpretation section, and sees, without, I hope, mind reading it out, the 2 subcategories of entitled person. And widower is obviously framed in terms of the law of marriage. B is not so framed. It's a slightly wider category if there is no widow or widower living with the tenant at the time of death. But of course, as the board knows, the administrative practice in Gibraltar has been to go somewhat wider than the words of the statute, because there is a discretion, and the policy is described in the judgments below. There is the opportunity in practice to apply for a joint tenancy, and there is one category of persons beyond legally married persons who can apply, and that is an unmarried couple who have a child in common. But of course that criterion also, of necessity, will, in its effect, if it's not necessarily its purpose, but certainly in its effect, it will of necessity exclude a same-sex couple, because even if they have a child, it couldn't obviously be a common child. Then I turn, if I may, to the Constitution.
Well, I suppose if they'd adopted in a country that allowed joint adoptions by
Yes.
Same-sex couples, they could have a child in common.
Yes.
But whether, of course, the Gibraltar
Whether it would be recognised.
would regard that as a
exactly.
child in common is
Yes,
unknown.
my lady's right, and a similar issue can arise, if I may say so, if my clients were to seek to marry in Spain, for example, even if that were possible, they've been advised it's not. Likewise, a civil partnership in England, they were told that they couldn't do it because of residence requirements, but even if that were wrong, we would submit it would be highly unlikely that the family law of Gibraltar would then recognise that. But that hasn't happened. The Constitution is behind tab 4 in the same volume, and as the board knows, it consists of a brief order in council by Her Majesty in this country, to which is annexed the Constitution, and it's chapter 1, which deals with fundamental rights and freedoms. And may I invite attention to certain of those provisions. First, section 1, on page 7. It's hereby recognised and declared that in Gibraltar there have existed and shall continue to exist without discrimination by reason of any ground referred to in section 14.3, but subject to respect for the rights and freedoms of others and for the public interest, each and all of the following human rights and fundamental freedoms. And then I would only emphasise in A, the enjoyment of property, and in C, the right of the individual to protection for his personal privacy, for the privacy of his home and other property. And that is then amplified in section 6, which deals with property rights, and section 7, which deals with protection for privacy of the home in particular. Now, do perhaps just emphasise subsection 3 in section 7, which talks about the concept of law. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of the section, to the extent that the law in question makes provision. I only emphasise that because we submit that it's an inherent part of any justification for interference with fundamental rights in the Constitution, that it has to be under the authority of law. And that then leads to that important finding by the acting Chief Justice, endorsed by Sir Paul Kennedy, that here the interference was not in accordance with law. May I turn, please, to section 14, which is the equality provision. And as we've now had clarified, it's common ground that this is a freestanding provision. In other words, it's more like the new Article 14 in the ECHR would be in the 12th Protocol, which the UK has not ratified. It's not tied to something falling within the ambit of another convention right, as the Article 14 provision is. It's a long provision, and of course it's central to this case, but I'll be forgiven, I hope, if I don't read it all out now. But can I emphasise certain passages? In subsection 1, I would invite attention to the last 3 words, because in my submission that makes it plain that the Constitution itself is envisaging that a measure may be discriminatory in its effect, even though it is not, as such, of itself discriminatory.
That's what, just indirect discrimination, basically?
Yes. And my Lord, I hope it's clear that the central thrust of our case is that this is a case of indirect discrimination against same-sex partners. Then the freestanding provision is in subsection 2. So we would say this is a public function performed by the Housing Allocation Committee. Subsection 3 sets out a long definition of discriminatory treatment, and I've made the point in my outline that it includes any other grounds as the European Court of Human Rights may from time to time determine to be discriminatory, and it's common ground in this appeal that the European Court has recognised sexual orientation, and so that is, as it were, read into this as an express ground of discrimination which is prohibited. And of course, discrimination can consist of not just imposing burdens on people, but as the last line and a half make clear in this subsection, where there are accorded privileges or advantages that are not accorded to persons of another such description. So the ability to have a joint tenancy, particularly the consequence of being able to have security of tenure and the freedom from anxiety, I would submit, which that then gives a person who is in a partnership, is an important privilege or advantage which some people in Gibraltar have, but not same-sex partners. And then subsections 6, 7 and 8 tie into 4, 5, subsections 4 and 5, in that 4 and 5 deal with law, and then 6, 7 and 8 deal with what are going to be administrative acts which may be authorised by law. It's a complicated provision, but for present purposes, I hope it's not necessary to deal with the detail of it. But what it does emphasise, I say again, is that there has to be authority of law. See, for example, the first few words of subsection 7. And then may I move, please, to section 18, the interpretation provision, and remind the board of subsection 8, at the bottom of page 22, a court or tribunal determining a question which has arisen in connection with a right or limitation thereof set out in this chapter must take into account any, and then judgment, decision, etc. of the European Court of Human Rights, whenever made or given, so far as, in the opinion of the court or tribunal, it is relevant to the proceedings in which that question has arisen. Now, I make the submission that was where the language and structure of a right in the Constitution is materially the same as in the ECHR, of course we would accept that the interpretation given to that in Strasbourg is going to be relevant. But we make the submission that section 14 is differently structured and is wider than Article 14. The Cerisola case has been referred to by my learned friend. Can I just give the reference? That's a decision of the board at volume 1, tab 14, in which at paragraphs 35 and 36, Lord Neuberger expressed the obiter view that section 14 of the Constitution is a freestanding right, unlike Article 14, and that's accepted by my learned friend, so I don't go to that authority. I would, however, like to show the board the Human Rights Committee's comment number 18 on the International Covenant on Civil and Political Rights. This is to be found in volume 6 at tab 77. Now, the board will know that the International Covenant, which the UK has ratified, but not incorporated into either domestic law or into Gibraltar law, contains a freestanding equality provision in Article 26. And what the Human Rights Committee charged with implementing and supervising the CCPR is doing here, as it does from time to time, is issue general comments on the meaning of various provisions in the Covenant. This was issued in 1989, and I invite attention to two passages. First, paragraph 6. The committee notes that the Covenant neither defines the term discrimination nor indicates what constitutes discrimination. However, Article 1 of the Convention on the Elimination of All Forms of Racial Discrimination provides that the term racial discrimination shall mean any distinction, exclusion, restriction, or preference based on race, colour, descent, or national or ethnic origin, which has the, and can I emphasise these words, purpose or effect of nullifying or impairing the recognition, enjoyment or exercise on an equal footing of human rights and fundamental freedoms in the political, etc. field. Similarly, Article 1 of the Convention on the Elimination of All Forms of Discrimination Against Women, without reading it all out, can I just invite attention to the words effect or purpose 2 lines further on. And in similar vein, I would submit paragraph 12 provides some assistance, because that expressly deals with Article 26 of the Covenant, and in about the 7th line, there is a sentence which begins, it prohibits discrimination. It prohibits discrimination in law or in fact, and I would emphasize the phrase in fact, in any field regulated and protected by public authorities. It's therefore concerned with the obligations imposed on states parties in regard to their legislation and the application thereof. May I turn at this juncture to one of the principal Strasbourg authorities on which we place reliance, which is the case of Flimenos. In volume 3 at tab 30,
The Human Rights Convention has been extended to Gibraltar, presumably.
Yes, it has.
But not incorporated.
That's my understanding. I'll be corrected if I'm... Yes, I see Mr. Yamas assists me on that, yes. And it's a well-known passage which we've cited in our printed case. Can I go straight to it, please? On page 424, at paragraph 44, the court has so far considered that the right under Article 14 not to be discriminated against in the enjoyment of the rights guaranteed under the Convention is violated when states treat differently persons in analogous situations without providing an objective and reasonable justification.
Sorry, again,
my
which
lord,
paragraph of your case?
It's volume 310.
May I just get that? It's underground 2 at paragraph 47 on page 17. And yes, it's in fact fully set out there. And what I invite attention to, of course, is the last half of that, the second half of that paragraph. However, the court considers this is not the only facet of the prohibition of discrimination in Article 14. The right not to be discriminated against is also violated when states, without an objective and reasonable justification, fail to treat differently persons whose situations are significantly different. And that's the fundamental submission we make. Similar comment was made, as it happens in the context of same-sex relationships, in the case of Frette and France, which is in the same volume at tab 39. Can I go straight to that paragraph? It's paragraph 39 on page 458. The facts of Frette are very different. They're much more like the decision of the House of Lords recently in G, which I will return to, and Frette was referred to in G. But the point I wish to emphasise for present purposes is simply that here is an example of the Court of Human Rights expressly using the Flimenos formulation of discrimination, where there is, without an objective and reasonable justification, fail to treat differently persons whose situations are significantly different. That they're being used precisely in the context of same-sex, alleged same-sex discrimination. Now, it's true that the court then went on to consider the wide margin of appreciation in the context, particularly of adoption practice. That's something that the House of Lords commented on in the case of G recently, and I would like to return to that. But essentially, my submission on that is going to be that even if one adopted the approach to be adopted under the Human Rights Act, which I say is not the right starting point because we're dealing with the Constitution of Gibraltar, but even if one were in England and apply, or Northern Ireland and applying the Human Rights Act, as in G, the House of Lords made it clear in G that where the Strasbourg Court has left a margin of appreciation, to member states, then it's open to a national court applying the Human Rights Act to take a view for itself and not necessarily wait for Strasbourg to speak first. Just on the concept of discrimination, before I leave that, can I also remind the board of the DH case, which is in volume 4. Can I briefly go to it? Volume 4, tab 47. This is the well-known judgment to do with racial discrimination against Roma children in the Czech Republic. But I need to go just to 2 paragraphs on general principles. They are behind tab 47 at page 117. At paragraph 175, in recapitulating the main principles, the court states that discrimination means treating differently without an objective and reasonable justification persons in relevantly similar situations. Well, we've seen that many times. And then after the possibility of factual inequalities being corrected, that's usually taken to be a reference to certain circumstances where there can be permissible affirmative action programs. And then the court states this: the court has also accepted that a general policy or measure that has disproportionately prejudicial effects on a particular group may be considered discriminatory, notwithstanding that it is not specifically aimed at that group, and that discrimination potentially contrary to the convention may result from a de facto situation, and we rely upon that limb as well.
It's a nice slide into indirect discrimination.
Yes, it is, my lady, yes.
In effect saying we've always been saying this, when in fact
Well,
they didn't say it anything like as clearly until DH, did they?
I would accept that, my
Neat
lady.
slide.
Yes. On the burden of proof, again, I anticipate this is common ground, but it's worth just noticing at paragraph 177 that the court has established that once the applicant has shown a difference in treatment, it's for the government to show that it was justified. In the housing context, the leading authority in Strasbourg is the judgment of the court in Kana, which is volume 3 at tab 40. Kana was decided in 2003, as I recall, shortly before argument was heard in the House of Lords in Gaydan.
It was between the Court of Appeal's
Yes.
decision in Gaydan and before argument in the House of Lords.
Yes, yes. And was very similar, as we shall see in a moment, factually, to Gaydan. And can I be quite frank with the board? I accept, as I have to, as advocate for the appellant, that factually both Kana and Gaydan, important though they were in moving the law towards recognising greater equality for same-sex partnerships. Factually, they concerned distinctions in law which were not at the point of marriage. And there had been some legislative extension to permit heterosexual, unmarried couples to enjoy security of tenure rights, for example. Let that be accepted. And that's why this case arises, frankly. And it's a difficult point that the board has to decide, if I may say so, on how far equality rights go. But we submit that the time has now come to recognise, as the South African Constitutional Court has done, that if the state draws the line at marriage and thereby, in effect, and necessarily excludes same-sex partners from, for example, security of tenure, that is a violation of the principle of equal treatment, whatever might be the position in relation to other unmarried subgroups. I say that, I hope helpfully to the board up front, because before I go to the some of the reasoning in this, it's important that the board should appreciate that factual distinction. The relevant domestic law statute in Austria at the time is set out on page 532 at paragraph 19. And for present purposes, it's sufficient, I hope, to point out that in subsection 2 of section 14 of the Rent Act, Austrian law provided that on the death of the main tenant of a flat, the persons designated in subsection 3 as being entitled to succeed to the tenancy shall do so, to the exclusion of others, etc. And they had to give notice within 14 days. And then the entitled persons are listed in subsection 3, and they are a spouse, but they also include a life companion, and then relatives in the direct line, including adopted children. Life companion is then in the final sentence on that page defined to mean a person who has lived in the flat with the former tenant until the latter's death for at least 3 years, sharing a household on an economic footing like that of a marriage. And essentially, the position was that Austrian interpretation of that provision had led to a situation where opposite-sex couples who were not married but fulfilled the definition of life companion could benefit from security of tenure. Same-sex couples could not. That was held by the court to be a violation of Article 14, taken together with Article 8. That part of the judgment begins at paragraph 34 on page 536. And I would commend to the board the whole of that passage from 34 to 43, but may I just highlight a few passages in view of the time. First, at paragraph 37, after setting out the definition of discrimination, the court states in the final sentence, furthermore, very weighty reasons have to be put forward before the court could regard a difference in treatment based exclusively on the ground of sex as compatible with convention. And then this, just like differences based on sex, differences based on sexual orientation, but require particularly serious reasons by way of justification. They then did examine the justification put forward by the state, and in particular, at the end of paragraph 39, they note, the government now submit that the aim of the provision at issue is the protection of the traditional family unit. The court can accept that protection of the family unit in the traditional sense is in principle a weighty and legitimate reason which might justify a difference in treatment. It remains to be ascertained whether in the circumstances of the case the principle of proportionality has been respected. So they go on to do the scrutiny, which in our respectful submission, the Court of Appeal and the First Instance Court in our appeal did not do. The aim of protecting the family in the traditional sense is rather abstract, and a broad variety of concrete measures may be used to implement it. In cases in which the margin of appreciation afforded to member states is narrow, I emphasise this, as the position where there is a difference in treatment based on sex or sexual orientation, the principle of proportionality does not merely require that the measure chosen is in principle suited for realising the aim sought. It must also be shown that it was necessary to exclude persons living in a homosexual relationship from the scope of application of section 14 of the Rent Act in order to achieve that aim. The court cannot see that the government has advanced any arguments that would allow such a conclusion. So they then use this formula in paragraph 42, the government have not offered convincing and weighty reasons, which again is seen in the case law ever since Karna. There has been a violation of Article 14 taken with Article 8. And without going to it, unless I'm asked to...
In this case, it was a gloss on the meaning of life companion that excluded it, wasn't it?
It was, exactly. Yes. My Lord, that's similar to the reasoning, if I may say so, adopted by the majority of the Lordship's House in Gaydan, which we're going to look at in a moment. where effectively a gloss was put on the Rent Act provision on security of tenure, using the strong interpretative obligation in Section 3 of the Human Rights Act.
But I think my Lord's point was the opposite.
Forgive me.
The Austrian court's interpretation
Yes.
of life companion had put a gloss on it.
Yes,
Yes.
The Austrian
yes.
court's interpretation.
They had interpreted it to
Yes.
be heterosexual.
And they simply couldn't justify that.
Yes, forgive me, I misunderstood.
And that was straight discrimination,
Yes.
not indirect at all.
Yes. That's straight discrimination. As your Lordship knows, we submit that where there is discrimination in effect, even if that's not the aim of the distinction drawn in law, a similar analysis has to be adopted. And it may be that if justification has to be gone through and the rigorous scrutiny done, in the right context, we would accept that it will be open to the state to justify certain measures. We're going to see later in this hearing, if I may say so, some examples of that. But it does have to be subjected to this scrutiny, and one can't say necessarily that in every context, drawing the line at marriage. Can I give one obvious example, if I may say so? If, say, the state were to offer public sector jobs only to married couples, and a same-sex partner made the same complaint as my client makes in this case, in my respectful submission, that again is a limited public resource. The state could again say that we're trying to promote the traditional institution of legal marriage. So far, so good. But in my respectful submission, the justification would still have to be analysed with great care. Would it be necessary to exclude persons living in a homosexual relationship from the scope of protection of jobs? I would respectfully submit the answer would be no. And the Smith and Grady case, which concerned automatic discharge of gay people from the armed forces, provides strong support, I would suggest, that to limit public sector jobs like the armed forces and exclude, of necessity exclude homosexual partners would not be permissible today. But it does depend on the context. And it's in some contexts like tax, as we've seen recently in a case called Corton, which I'll return to. The Court of Human Rights has followed earlier decisions and readily accepted that the state is entitled to draw the line at marriage, even if it has the effect of excluding same-sex partners. Can I suggest to the board why that on analysis may be right, but is distinguishable from the present scenario? It's this, that as I understand it, the law on taxation of married couples is itself a complicated sub-area of the law of taxation, and indeed, it's not my field of expertise, but I anticipate in the area of family law. In other words, the marital relationship, because it is a legal concept, carries with it a whole framework, a network of rights, obligations, responsibilities, which then have been followed through in the tax regime to duties as well as allowances and reliefs. And as I understand it, the essential rationale for saying that the state is entitled to draw the line at marriage in that context is really this, that if you start to pull at one thread of a very delicate spider's web of interrelationships, without the state carrying out an overall review of what people's rights and obligations, reliefs and allowances ought to be, then that would be something impermissible for a court to do. But what we say is that if you take what I hope is the obvious example of restricting public sector jobs to married couples, that would not be justifiable in principle if it had the effect of excluding same-sex partners, which it would. Adoption provides now a delicate context where historically it tended to be thought that gay people should not be allowed to adopt, and social attitudes and the law reflecting them have moved on.
It's interesting. Taxation is an area where, if you look at the regime, and it may be very complicated, you may find that there are very good reasons for discrimination. Strasbourg seems to say, well, it is a complicated area. We're not even going to look to see whether the particular regime justifies this.
Well, I would respectfully agree, but what I would suggest is that there is a spectrum of possible scenarios, and that one does have to apply the fundamental principles in Strasbourg, which are as laid out in Kana and other cases. May I just give another reference to similar effect to Kana? It's the case of EB and France.
Mr. Singh, before you leave this, you've just been referring briefly to Courton, and I'm sure we're going to look at it.
I'm going to come back to it.
Yes, okay. Well, it just occurred to me that I don't, as I've read it, perhaps I've missed it, but I don't think there's anything in the judgment which refers to pulling one thread out of the spider's web, to use your analogy.
No.
Or distinguishes taxation regimes from any other particular type of regime.
Your Lordship is right.
Right. Well, we'll look at it in due course.
We'll look at it. And what I'm suggesting is that if one is looking for a principled basis for distinctions in this difficult area of law, that may provide a principled basis which is consistent with Article 14 jurisprudence, generally. But I have other submissions to make about Courton, such as that it's to do with Article 14 and not the Constitution of Gibraltar, and that in any event it ought not to be followed. But of course I recognise that it's there, and I have to deal with it. EB in France is another case where the court said that where sexual orientation is an issue, there is a need for particularly convincing and weighty reasons to justify a difference in treatment regarding rights falling within Article 8. Can I just give the reference, because it's a well-known principle? EB is in Volume 4, tab 48, at paragraph 91. And similarly, I hope without needing to go to it, L and V against Austria, a similar comment is made at Volume 3, tab 38, at paragraph 45. What I would propose to do now is to go to some of the cases which have arisen on Article 14 under the Human Rights Act in UK case law. And the principal one, because it concerns housing, is Gaydan and Godin Mendoza, which is in Volume 1 at tab 10. And this was a decision of their Lordship's House concerning the Rent Act. And I say again what I said before going to Kana, that factually there is a point of distinction from Gaydan, because the legislative history was that in 1977 we had the Rent Act, and then in 1988 there was a Housing Act which amended it to extend the protection for security of tenure to unmarried heterosexual couples. At least that was the interpretation placed on that provision by their Lordship's House in a case called Fitzpatrick in 1999. And so once the Human Rights Act came into force, the issue arose whether their Lordship's House should reconsider that interpretation of the Rent Act under the strong interpretative obligation in Section 3 of the Human Rights Act. By a majority of 4-1, the House of Lords held that Fitzpatrick would now not be decided in the same way, and therefore it was possible to read the concept of spouse as including same-sex partners, not just heterosexual unmarried partners. And there was unjustified discrimination, so there would have been a breach of Article 14, and that's why Section 3 had to be used in that way. But what I would like to do, if I may, is invite attention to certain of the salient passages that, in the interest of time, I'm not going to read at length, but I do invite attention first to the opinion of Lord Nichols, particularly at paragraphs 9 to 20, time doesn't permit me to read all of that, obviously, but I invite attention in due course to paragraphs 9 to 20. Can I emphasise in paragraph 9, at the top of page 9 of this printout. In the third line, Lord Nichols said, to be acceptable, these distinctions should have a rational and fair basis. And then this sentence, like cases should be treated alike, unlike cases should not be treated alike. And I emphasise that because it echoes what the Court of Human Rights has said in Flimenos.
Yes, they've said that, and as a proposition, it's a pretty broad one. I would suggest one ought to put in not necessarily be treated alike.
Yes, more like that. I think that's fair, yes. Yeah,
Well, it's all subject to justification in any event,
exactly,
isn't it?
exactly.
Both the like, and of course the other thing that's the problem is what's a like case
Yes,
and what's an unlike
well,
case,
indeed.
which are the big problems.
Yes.
The proposition itself is. But of course the other interesting sentence, or the many interesting sentences in these paragraphs, but is to be acceptable, these distinctions should have a rational and fair basis.
Yes.
One of the difficulties, as is apparent from what I said in that case, is seeing what's rational about this discrimination.
Yes. Well, my lady,
How is it rationally related to
my lady,
some declared mantra about protecting marriage?
I would respectfully agree, and if we get to the justification state, it's really paragraph 11 of my outline submissions, that when we get there, my respectful submission is that actually, although things are often uttered as a mantra, like promoting marriage or protecting the traditional family unit, that as my lady well knows, one of my fundamental submissions is going to be that one of the important roles of a court of law in this context is precisely to subject to close and rigorous scrutiny the justifications offered by the state, because sometimes they will pass muster. At other times they will not, and it's important that the court should be a guardian of the rights of minorities in particular, a point that has been made many times by the House of Lords and other courts. The other thing that one does get strongly from Lord Nichols' opinion, if I may say so, is that it doesn't help, frankly, to say, well, this is an area of social and economic policy because it concerns allocation of limited public resources like housing. That concerned housing in a wider private sector sense as well. Lord Nichols particularly dealt with this at paragraph 19. And the point Lord Nichols is really making is that even in last sentence or two, even in such a field, where the alleged violation comprises differential treatment based on grounds such as race or sex or sexual orientation, the court will scrutinise with intensity any reason said to constitute justification. The reasons must be cogent if such differential treatment is to be justified. Now, that, as I understand it, is really reflecting the kind of comments we've seen in Strasbourg about particularly weighty reasons, convincing reasons, and so on. The point that my lady put to me, if I may say so, is dealt with in paragraph 17 of Lord Nichols' opinion, where in the fourth line he states, Parliament may readily take the view that the survivor of them has a special claim to security of tenure even though they are unmarried. But this is where the scrutiny, as it were, happens. But the reason underlying this social policy, whereby the survivor of a cohabiting heterosexual couple has particular protection, is equally applicable to the survivor of a homosexual couple. A homosexual couple, as much as a heterosexual couple, share each other's life and make their home together. They have an equivalent relationship. There is no rational or fair ground for distinguishing the one couple from the other in this context. Now, of course I accept, and I hope I've been frank about this, the factual distinction being compared is between unmarried heterosexual partners and same-sex, but unmarried partners. But as we'll see in a few moments, when faced with the similar problem, the South African Constitutional Court has not hesitated to say where the line drawn by the state is at the point of marriage, not the line in Gaydar. There also, we do have to examine with care what the justification might be in effect, if not in purpose, for excluding same-sex partners too. And if that justification doesn't withstand this intense scrutiny, then it will be a violation of the right to equal treatment, although sometimes it will be justified. Adoption might be a context subject to the discretion being needed as per G. In Gaydan, several members of the House of Lords, Lord Billett, I should say, dissented on Section 3 issue.
He didn't dissent on the discrimination
No,
issue.
no,
It was
exactly.
simply on whether
Precisely.
Section 3 permitted
Indeed.
us to make the difference.
Exactly, exactly. So there was a unanimity in the House on the underlying substantive question of equal treatment. He dissented on Section 3. Lord Steyn and Lord Roger, in their opinions, addressed the Section 3 issue, but agreed otherwise on the discrimination issue. And the other principal opinion was given by my lady, Baroness Hale. And I invite attention in due course, particularly to paragraphs 130 to 143. But again, because it's a long passage, I'm not going to take time unless I'm asked to. But I do emphasise certain passages. First, I do emphasise paragraph 132. The first sentence, such a guarantee of equal treatment is also essential to democracy. Democracy is founded on the principle that each individual has equal value. And that, of course, I would submit is fundamental value reflected in Section 14 of the Constitution of Gibraltar. And I also emphasise the last couple of sentences. Finally, it is a purpose of all human rights instruments to secure the protection of the essential rights of members of minority groups, even when they are unpopular with the majority. Democracy values everyone equally, even if the majority does not. And can I just pause there in the citation to inform the board that Mr. Restano, of course, practices in Gibraltar, tells me that the position in Gibraltar, of course, it's a small, closely knit community, not dissimilar perhaps to parts of the United Kingdom that have been considered in Strasbourg, like Northern Ireland in the Dudgeon case. And recently, for example, there was an attempt made in the Gibraltar Parliament to equalise the age of consent for sexual relations, which we would submit is a requirement of the Strasbourg case law. Sutherland was the case concerning the UK about that. That attempt failed in the parliamentary process, and it perhaps underlines the thought that lay behind this paragraph, if I may say so, in my lady's opinion. The next passage I would emphasise is paragraph 136 at the bottom of that page, where my lady said a difference in treatment on grounds of sexual orientation is particularly suspect for the reasons given earlier. The grounds put forward to justify it require careful scrutiny. Now, my lady then did say this at 138, and I have to acknowledge it, that we are not here concerned with a difference in treatment between married and unmarried couples. The Court of Human Rights accepts that the protection of the traditional family is in principle a legitimate aim. The traditional family is constituted by marriage. The Convention itself, in Article 12, singles out the married family for special protection by guaranteeing to everyone the right to marry and found a family. Can I just pause there to reflect that Section 15 of the Gibraltar Constitution also includes a right to marry, although it's not exactly framed in the same terms as Article 12, because, of course, Article 12 is an international treaty and it talks about national laws. Section 14 is a national instrument and doesn't talk in those same terms about national laws, but the burden of my submission is not going to be based on that distinction. It's a more basic principle I seek to persuade the board of. And I continue with a citation from 138. Had paragraph 2 of Schedule 1 to the Rent Act stopped at protecting the surviving spouse, it might have been easier to say that a homosexual couple were not in an analogous situation, but it did not. Now, I hope I've fairly reminded the board of that passage, and there are similar passages elsewhere in this opinion. All I do say is that was not the issue of law before their lordship's house there, and my lady was saying that it might have been, not that it would have been justified. What I would respectfully suggest is that the same exercise of rigorous scrutiny has to be undergone. What comes out at the end of the day will depend on the arguments in this case, not the arguments in Gaydown, which didn't need to be made. And
Of course,
I would emphasise,
part of the problem in Gaydown was that the respondents' arguments were very much based on marriage,
yes,
which was not the issue.
yes, yes,
So sometimes one has to read a passage like
Yes.
that in the light of
yes. Well,
the arguments presented.
I would accept that, lady. And what my lady also said at the end of 139 was that what matters most is the essential quality of the relationship. It's marriage-like intimacy, stability, social and financial interdependence. Homosexual relationships can have exactly the same qualities of intimacy, stability, and interdependence. And I do respectfully invite the board, when you go back, to look at the early passages in the judgment of the acting Chief Justice, where, if I may say so quite eloquently, he set out the impact on my clients. And this is something like now a 20-year-old, stable, I would say marriage-like relationship. And I hope it goes without saying that it's causing very serious anxiety to them not to have the security of knowing what might happen if heaven forbid, one were to die in a car accident tomorrow. At paragraph 143, my lady says this in about the fifth line: but what could be the legitimate aim of singling out heterosexual couples for more favourable treatment than homosexual couples? It cannot be the protection of the traditional family. The traditional family is not protected by granting it a benefit which is denied to people who cannot, and I would emphasise that word, or will not become a traditional family. Now, if I may respectfully say so, in the case where the issue may actually have to be decided, it may be that there is in principle a distinction to be drawn between people who cannot, on the one hand, and people who will not, on the other. I don't want to preclude an argument on behalf of the latter category. That might be another case one day. But what I emphasise is that mine is a case of people who cannot, because they're not allowed by law to marry each other.
Well, we leapt that with one graceful bound in G, didn't we?
Yes.
From cannot to will not.
Yes, yes, indeed.
Oh, my bound was less graceful than the other members
Yes.
of the court.
If I continue with the citation, what is really meant by the protection of the traditional family is the encouragement of people to form traditional families and the discouragement of people from forming others. There are many reasons why it might be legitimate, again I emphasise the word might, to encourage people to marry and to discourage them from living together without marrying. These reasons might have justified the act in stopping short at marriage. Once it went beyond marriage to unmarried relationships, the aim would have to be encouraging one sort of unmarried relationship and discouraging another. And then, passing over the next sentence, as Lord Justice Buxton pointed out in the Court of Appeal, it's difficult to see how heterosexuals will be encouraged to form and maintain such marriage-like relationships by the knowledge that the equivalent benefit is being denied to homosexuals. Now, may I pause there and make a submission that, in my respectful submission, the analysis is the same if one has a distinction in the law which stops at marriage, because one poses the question, well, it's difficult to see how heterosexuals will be encouraged to form and maintain marriage by the knowledge that the equivalent benefit is being denied to homosexuals who cannot marry. And my lady continued, the distinction between heterosexual and homosexual couples might be aimed at discouraging homosexual relationships generally, but that cannot now be regarded as a legitimate aim. So there the state would fall down at that hurdle. It's inconsistent with the right to respect for private life according to everyone, including homosexuals. It cannot be legitimate to discourage stable, committed, marriage-like homosexual relationships as the thought which qualify the survivor to succeed to the home. I would respectfully submit that exactly the same principle could apply in this case. Society wants its intimate relationships, particularly, can I emphasise this word, this phrase, particularly but not only if there are children involved, to be stable, responsible and secure. It's the transient, irresponsible and insecure relationships which cause us so much concern. Again, I would submit that that analysis and statement of principle is equally applicable in our case. And I emphasise that because one of the points, no doubt, that the respondents will make is that the law, at least the policy, not the law, the policy in Gibraltar didn't stop at marriage, that there are some unmarried couples, as we've seen, where they have a child in common. And I emphasise this passage because my lady was there saying that, yes, of course, if there are children involved, that may well lead to a need for special protection. But my lady was saying that's particularly so, but not only if there are children involved. My lords, my lady, can I more briefly turn to the well-known Belmarsh case, A, and Secretary of State for the Home Department, which is in Volume 1 again, at the next tab, tab 11. And there are two passages I would wish to emphasise. First, in the opinion of Lord Bingham, which is at page 29 of this printout, at paragraph 68. And it's a well-known sentence right in the middle of that paragraph, where His Lordship said, in line 5, what has to be justified is not the measure in issue, but the difference in treatment between one person or group and another. In other words, where it's a discrimination analysis which is being done, it's the difference in treatment, not the underlying measure, which has to be justified. In that case, of course, it was the use of immigration status to be a foreign national, of course, in the right context, is a perfectly appropriate, rational, maybe even a necessary criterion to use to deport someone. A citizen, by definition, cannot be deported. But what their lordships held in A was that to use that legal status as a point of distinction to justify detaining terrorist suspects without charge was not appropriate, it wasn't rationally connected to the end in view, and it wasn't necessary. In my respectful submission, if one tries to delve below the social policy in the present context, it is, I would suggest, as Lord Nichols and Baroness Hale said in Gaydan, is that the state has a legitimate interest in protecting stable relationships of an intimate kind, marriage-like, as my lady and Lord Nichols put it, so that people will enjoy security of tenure. So the principal rationale is to give people that security of tenure. And when one asks, well, is it necessary to discriminate in order to give that security of tenure to married couples? Is it necessary, therefore, to exclude same-sex partners who have very much the same qualities of intimate, stable relationships? In my respectful submission, the answer is no. It doesn't further that end.
Could you identify the category of person against whom there is unfair discrimination? There seems to me there are a number of choices. They can be couples
Yes.
who are in a long-term relationship but are not married,
Yes.
or a narrower category, couples who are in a long-term relationship who would like to be married but cannot be married,
Yes.
or simply couples in a relationship who are not married.
Yes. My Lord, in my submission, for the purposes of this appeal, the category that I'm invoking is the category of persons who are in a long-term same-sex relationship and therefore cannot marry as a matter of law.
So you're going for the second of the
Yes.
three.
perhaps a little, it would be difficult if you had to throw into the mix, but who would like to get married if they could, because
Yes.
there'll be some who, even if they could,
Yes.
would have the same kind of fundamental objection to matrimony
I-
that heterosexual couples in a long-term
I accept
relationship
that, my lord, and that would be, if that were the factual and legal framework in Gibraltar, it would raise a different legal issue. And without conceding the point, because it's not the point that arises in this case, I would accept, my lord, that it might be more difficult for someone to complain in that situation. It's similar to the sort of argument that I understand, I don't know the details, but some people are making now that this country has civil partnerships. Some people are making the sort of arguments that have succeeded in some jurisdictions in North America and in South Africa, that it's not good enough. That we want to have the legal right to marry, and then your lordship is quite right, that even if the state confers the legal right to marry on homosexuals, there may one day be categories of people who still object to the institution and don't wish to take advantage of that. Whether they could succeed in the argument, I would acknowledge would be a more difficult issue. For present purposes, my fundamental submission is that it's not the issue in this case, because the state has chosen to have a legal framework in which there is not even the possibility of civil partnerships, let alone the possibility of legal marriage. And that once the state takes that policy choice, and I don't attack that, because I don't need to attack it in this case, what it can't do legitimately in my submission is use the necessary consequence of that, of its own legislative decision, to exclude all same-sex partners, whether or not they wanted to take up that advantage if it had been offered to them. My lords, my lady, I was on the Belmarsh case, and the other passage I wanted to remind the board of is in the opinion of my lady, Baroness Hale, at paragraphs 232 and following. That's page 52 of this printout. It starts at the bottom there, paragraph 232. And it goes down to 238. Again, it's a well-known passage, and I don't take time reading it all out now. 232 to 238. 232. But I do, of course, place particular emphasis on what my lady said at paragraph 237, in similar vein to what she said in Gaydown.
Oh dear, repeating myself.
Well, and quoting President Jefferson.
Yes.
Can I move on briefly to another decision in their Lordship's House, AL Serbia, which is in the same volume of authorities, at tab 15. The principal opinion for their Lordship's House was given by my lady Baroness Hale. This arose in an immigration context, and it wasn't to do with sexual orientation. It was to do with children who didn't have with them, their parents. But there are some important points of general principle about equality law to be found starting at page 5 of this printout, from paragraph 22 through to paragraph 31. And again, I hope I'll be forgiven for taking this quickly because of the time, but can I emphasize two particular points which emerge from my lady's analysis? The first emerges most clearly from paragraph 28, where you said, I say all this because so much argument, and I was responsible for some of that argument, has been devoted in this case, and in too many others, to identifying the precise characteristics of the persons with whom these two young men should be compared. This is an arid exercise. And you particularly emphasized, if I may say so, and this is the second fundamental point I derive from this passage, that, as you said at paragraph 27, there are also, as Lord Walker recognised in the Carson case, dangers in regarding differences between two people which are inherent in a prohibited ground and cannot or should not, I think that should be changed.
Yeah.
In parentheses, I would add there, such as sexual orientation, as meaning that the situations are not analogous. For example, it would be no answer to a claim of sex discrimination to say that a man and a woman are not in an analogous situation because one can get pregnant and the other cannot. This is something that neither can be expected to change. If it is wrong to discriminate between them as individuals, it's wrong to focus on the personal characteristics which are inherent in their protected status to argue that their situations are not analogous.
Well, that was the argument that was used for a very long time to justify sex discrimination.
Indeed.
Men and women are different, therefore it's perfectly sensible to discriminate
Indeed.
between them. And that had to be knocked on the head.
Absolutely. And as my lady knows, and no doubt had in mind in that paragraph, the courts in the UK had said that, in fact, discrimination on the grounds of pregnancy was lawful, and it was the ECJ which had to correct that under community law. But what I would respectfully submit now is that applying that thinking to the present case, here too we have a situation where the state, when one stands back from it, the state says, as a matter of law, you same-sex partners cannot marry each other. The state then, it seems, uses that inability in law to marry as a reason for denying equal treatment to married couples. So, in my respectful submission, the state is using, in an illegitimate way, I submit, its own doing as a matter of law. It's using what my lady called a criterion which is inherent in a prohibited ground. The reason why my clients can't marry each other is because they are homosexual. So it's using that then against them. That's not an answer to a claim of unequal treatment. It's part of the problem. And my lady also said this, and this is the third point I derive from this important passage, is that the European Court of Human Rights, although it does in some cases say that two persons are not relevantly analogous, that in the vast majority of cases it tends not to be too interested in what my lady called the arid exercise of finding the right comparator. Particularly, my lady said this at paragraphs 24 and 25, where you quoted from Professor Feldman's book, itself quoted by Lord Walker in Carson. And I think that in turn was quoting the Dutch textbook on the European Convention by Professors Van Dijk and Van Hoof. The last two lines of that quotation makes the point. In most instances of the Strasbourg case law, the comparability test is glossed over, and the emphasis is almost completely on the justification test. As I understand the reasoning, and I'll be corrected if I'm wrong, what my lady and others have said in these cases, therefore, is this, that it's all too easy to engage in an arid exercise of saying, well, two persons are not similarly situated. It may be important to analyse what the strength of the justification put forward is. And it may be that at the end of that exercise, you reach two conclusions. One, that the justification is made out, and possibly two, that for that reason, the two persons are not in an analogous situation. But that to do it the other way around risks injustice, because you may end up, as my lady has observed, saying, well, men and women can be treated differently because men and women are different. My Lords and Lady, can I now turn to the decision of their Lordships House in G, which is at the next tab, tab 16. This is the well-known case arising from Northern Ireland, where the ability to adopt was limited to those who were married, and so it doesn't concern...
The ability jointly to adopt.
Forgive me, yes, jointly to adopt, exactly.
It's worth emphasising that, because
You're quite right.
each of the partners, well,
Exactly.
obviously the mother wouldn't have wanted to adopt, but
Yes.
the could adopt singly.
Yes, that's very fair.
Why do I think of this as re-P?
Because it does, when it was first handed down and not reported, it did come out as re-P. When reported, it became re-G. I don't know why.
It's induced a considerable amount of schizophrenia.
It has. In many cases, it now causes confusion. But there it is. Now, my lords, my lady, I'll be guided by the board, but I'm very much aware of the clock. So what I'm going to try to do is to distill 4 basic points that I say can be derived from the various opinions of their lordships. If you would like me to go to specific passages, of course I will, but it may save time if I just give those points and the references.
I think that would be satisfactory.
I'm grateful. Obviously it's important,
Yes.
and they should all be read fully. Can I just make my 4 submissions then? First, I say this, that even in the context of the Human Rights Act, which is differently structured from the Constitution of Gibraltar, the House of Lords held that in cases falling within a state's margin of appreciation, it was open to a national court, as it were, to outrun the European Court. That's using Mr. Justice Dudley's phrase. And the references are these. Lord Hoffman at paragraphs 29 to 38, Lord Hope at paragraph 50, my lady, Baroness Hale, at paragraphs 116 to 120, and Lord Mance at paragraphs 126 to 130.
I would have thought it's always open to a national court to outrun Strasbourg when it is, as it were, extending protection, even if it does so,
Well,
even if there's no margin of appreciation.
well, my lord, the
You
difficulty...
go further than Strasbourg requires.
The difficulty, as I understand it, has arisen because, although Section 2 of the Human Rights Act is similarly worded to Section 18.8 of this Constitution, in that all it requires on its face is that the courts of this country should take account of the Strasbourg jurisprudence. What their Lordships' House have now said in a number of leading cases, particularly Ulla at paragraph 20 and Alskany at paragraph 106, is that, generally speaking, the courts of this country should follow and not outpace,
Yes.
no less and no more.
Sorry, I thought you'd said a national court as a matter of a general proposition.
Forgive me. Yes.
The national court.
Yes.
Yes, under our jurisprudence.
Yes.
No
Under the
more,
Human
no
Rights
less.
Act.
Yes.
So what...
Strasbourg wouldn't object if you go much
no,
further
Strasbourg
than they've
wouldn't
gone.
at all.
Yes,
Of course
yes.
not.
That's the whole point. But
Yes.
my lord, what I emphasise in this first submission about G is that even where it was a case under the Human Rights Act and not a national constitution, the House of Lords recognised that at least where there is a margin of appreciation, the House of Lords, did not have to wait for Strasbourg to decide the point and could reach a view which might be said to be going further than any Strasbourg case had previously done.
And of course, this is in the context of telling a national legislature,
Yes,
albeit not Parliament, that it's got it wrong,
yes,
which is a different context from developing the common law or
Yes.
applying or interpreting legislation in where there's a discretion or whatever. It's basically saying you cannot maintain this prohibition, which is in the legislation.
Yes.
And it's that context in which
Yes.
nationally
indeed.
caution seems
Indeed,
particularly appropriate.
and I would be entitled, my lady, to observe that in our appeal, we don't actually have legislation. It is an administrative practice. And so insofar as there may be scope for arguments about a discretionary area of judgment and so on, in the hierarchy of norms, I would suggest that administrative practice is much more readily to be second-guessed by a court than perhaps a democratic act might be. The second...
If it is within the margin of appreciation,
yes.
then the administrator is entitled to take a view.
It's entitled to take the first view, but in the national context, the margin of appreciation is not a relevant doctrine. It's a doctrine of international law. I would accept that there's the concept of discretionary area of judgment.
It's also a question of separation of powers, isn't it?
Well, yes, yes, but as my lady has observed, G is a powerful illustration that here there's a court of law telling the legislature, admittedly secondary legislation, but nevertheless telling the maker of legislation that it has drawn the line at a point which violates human rights and was struck down.
Yes.
So in the right case, it can and should be done.
Yes, I find a little elusive this idea that starting point is no more and certainly no less.
Yes.
But if Strasbourg has said, well, it's pretty finely balanced, but we'll give them the benefit of the doubt because the margin of appreciation, that then gives us the latitude we need to move a little bit more than Strasbourg. Yeah. I mean, that's the thinking, isn't it?
I said the leap was less elegant in my case than it was in the case of Lord Hoffman, who had no doubt about the matter.
Indeed. But I suppose I am also entitled to make the observation that whether or not it's right in the context of the Human Rights Act, we don't have to concern ourselves with that because I'm dealing with the national constitution. To make the obvious point, the Dutch courts are perfectly entitled to interpret the Dutch constitution as conferring rights on people within the Netherlands, and even if the Strasbourg court had never gone anywhere near the point. Second thing we derive from G, my lords and ladies, is this. Although the case was not itself concerned with same-sex couples, it is of some significance that Lord Hoffman cited with approval a decision of the Constitutional Court of South Africa, which did concern adoption by same-sex couples. And that is a case called Dutoit, and he referred to it at paragraph 17. Similarly, Lord Hope at paragraph 54. The third point I derive from G is that, like Gaydan, the case emphasises the particular responsibility borne by the courts in protecting people from discrimination, especially minorities. And there are two references. Lord Hope's opinion at paragraph 48 and Baroness Hale's opinion at paragraph 122. And fourthly and finally, the case illustrates the important point that even discrimination between married couples and unmarried couples does need to be justified. It may or may not be justified in the relevant circumstances in accordance with the principle of proportionality. Now, in that case, it was held not to be justified to have an absolute blanket bar because, as I understand it, the paramount interests were the interests of the child, and that it might be that exercising a discretion in a particular case, a same-sex partnership would constitute a perfectly acceptable family to adopt jointly, as my lady reminds me, to adopt jointly that child. Now, my lords and lady, my submission is going to be, when I come back to analyse the Court of Appeal's reasoning in our case, that it wrongly thought that the case simply turned on its context. That was the outcome of the application of the principle of proportionality. It does not mean that in other contexts there is simply no need for justification to be scrutinised. I leave G there, but I just want to add this, that another case in which the distinction between a married father and an unmarried one did require justification, although on the facts it was held to be justified, a case which illustrates that proposition is the Strasbourg judgment in McMichael. McMichael, I won't go to it, but the reference is volume 2, tab 26, and it's paragraphs 94 to 99 of the court's judgment, 94 to 99. Can I move to a slightly different topic? And it's that part of my submission which places emphasis on the principle that an interference with a human right must be in accordance with law. It's a basic proposition. Can I just give the reference? It's illustrated by many cases, but we've put one in the bundle. It's Holford, which is volume 2, tab 24, at paragraph 49. And without, I hope, elaborating the point at unnecessary length, can I just remind the board that the essential requirements of the quality of law are that it not only has a source in domestic law, so for example there is a legal power to do something, but it goes beyond that, that the law must be foreseeable and accessible. And that entails in consequence two aspects. One is that it must be published, it must be publicly available. And the second is that it must be crafted with sufficient precision. Here, as the acting Chief Justice found, as endorsed by Sir Paul Kennedy on appeal, the administrative practice is not written down anywhere, and therefore it's not accessible, and it's not formulated with sufficient precision. But the emphasis of the point is on its lack of accessibility. My Lord, my Lady, what I would like to do at this juncture is to show the board some of the key decisions of the Constitutional Court of South Africa, because as you know, I place particular reliance.
They're ahead of everyone else, and they're basically ahead of everybody else in this particular sphere, and you would like us to catch up with them for the benefit of Gibraltar.
Well,
Were they ahead of Ontario and Massachusetts?
I'm sorry. No.
Were they ahead of Ontario and Massachusetts?
No,
I think not.
No. We've set out the comparative case law at length in our printed case, and I'm not going to take up time unnecessarily by going to all of the many jurisdictions. It's fair to say that sometimes cases have gone against people, but certainly in North American courts, the tendency, if I may say so, in the last decade or so, particularly in Canada and also in Massachusetts and Hawaii, has tended to be, if I may say so, favourable to equal rights for gay couples. I accept it hasn't been universally so, but very clearly, and I would submit, most directly helpful to the present legal issue have been the South African cases. And I say that because at least two of those cases concerned state measures which drew the line at marriage. And so the courts had to ask, well, is this discrimination on grounds of sexual orientation at all? Because that is its effect. And if it is it justified? And they held that it was such discrimination, and they held it not to be justified in those particular contexts. The two principal authorities, and there will be one or two others to comment on, but the two principal ones are an immigration case first called National Coalition and Minister of Home Affairs. And this is to be found in volume 7, which will, I think, be a different colour from the others. It's a white volume, supplementary volume 7. And it's a tab 81.
It's a supplemental one, isn't it?
If my lord doesn't have it, we can provide a spare. Yes.
Is it here?
It was here. It was waiting for us.
My lord, we do have a clean...
I got it, yes.
I've got it. The judgment, the principal judgment for the Constitutional Court was given by Justice Ackerman and the other members of the court, as we see from page 89, concurred. And the issue is helpfully defined in paragraph 1. Two important questions.
So this was unanimous, was it?
Yes.
Yeah.
The first, paragraph 1, the first important question is whether it is unconstitutional for immigration law to facilitate the immigration into South Africa of the spouses of permanent South African residents, but not to afford the same benefits to gays and lesbians in permanent same-sex life partnerships with permanent South African residents. So that's the one I'm going to focus on. And then the measure in issue is set out on pages 12 and 13 at paragraph 15. And it's to do with immigration permits. South Africa has a system of immigration law which confers powers on regional committees, and the offending provision was found to be subsection 5 of section 25 of the Aliens Control Act of 1991, and subsection 5 UC uses the criterion of a spouse for relevant purposes.
I'm sorry, where's
My Lord, page 13.
13?
Yes, it's the bottom of that page.
I see, yes.
Subsection 5 has the word spouse in it. So that's what was said to be the offending limitation, because of necessity it excluded same-sex couples. Can I then please turn to page 35 at paragraph 38? It follows that same-sex partners are in a different position from heterosexual partners who have not contracted a marriage and have not become spouses. As will be emphasised later in this judgment, it is unnecessary in this case to deal at all with the position of such unmarried heterosexual partners. And that is my submission to the board. The respondent's submission that gays and lesbians are free to marry in the sense that nothing prohibits them from marrying persons of the opposite sex is true only as a meaningless abstraction. This submission ignores the constitutional injunction that gays and lesbians cannot be discriminated against on the grounds of their own sexual orientation and the constitutional right to express that orientation in a relationship of their own choosing. I should say that earlier in the judgment, Justice Ackerman has pointed out that South African law of marriage is very similar to English law of marriage and Gibraltar law. It doesn't allow same-sex marriage. Then I turn, please, to page 45, at paragraph 45. Where it is said, I turn now to deal with the discriminatory impact, can I emphasise that word, impact, of section 25.5 on same-sex life partners. I agree with the submission advanced on the respondent's behalf that section 25.5 is manifestly aimed at achieving the societal goal of protecting the family life of lawful marriages, which I understand to mean marriages which are formally valid and contracted in good faith and not sham marriages for the purposes of circumventing the Act, and certain recognised customary unions. By making the provision for family reunification, in particular by entitling spouses of persons permanently and lawfully resident in the Republic to receive permanent residence permits. The pertinent question that immediately arises is, what is the impact of being excluded from these protective provisions on same-sex life partners? And then...
I suppose, did the Constitution protect family life as such?
I don't know the answer to that immediately, my Lord. Can we check that and try and assist the board in due course? The next passage I would go to is page 52. I'm told by Ms Monaghan that it does in section 7. At page 52, at paragraph 53, Justice Ackerman, after a long analysis, including of comparative law from Canada, says this: the message that the total exclusion of gays and lesbians from the provisions of the subsection conveys to gays and lesbians and the consequent impact on them can, in my view, be conveniently expressed by comparing A, the facts concerning gays and lesbians and their same-sex partnerships, which must be accepted, with B, what the subsection in effect states. 1. Gays and lesbians have a constitutionally entrenched right to dignity and equality. That is true in Gibraltar. 2. Sexual orientation is a ground expressly listed in section 9.3 of the Constitution. Now, that's not in terms true in Gibraltar, but it's common ground that it's a ground in Strasbourg, and therefore it's been implemented by section 14.3 of the Constitution of Gibraltar. 3. Prior criminal proscription of private and consensual sexual expression between gays arising from their sexual orientation and which had been directed at gay men has been struck down as unconstitutional. Well, I don't think it's been struck down, but it doesn't exist any longer in Gibraltar, subject to the equalisation of age point. 4. Gays and lesbians in same-sex life partnerships are as capable as heterosexual spouses of expressing and sharing love in its manifold forms, including affection, friendship, eros, and charity. I would submit that is true in Gibraltar as elsewhere. 5. They are likewise as capable of forming intimate, permanent, committed, monogamous, loyal, and enduring relationships, of furnishing emotional and spiritual support, and of providing physical care, financial support, and assistance in running the common household. Also, I submit, in Gibraltar. 6, they are individually able to adopt children, and in the case of lesbians, to bear them. Also true. In short, they have the same ability to establish a consortium omnis vitae. Finally, and of particular importance for purposes of this case, they are capable of constituting a family, whether nuclear or extended, and of establishing, enjoying, and benefiting from family life, which is not distinguishable in any significant respect from that of heterosexual spouses. The subsection in this context in effect states that all gay and lesbian permanent residents of the Republic who are in same-sex relationships with foreign nationals are not entitled to the benefit extended by the subsection to spouses married to foreign nationals in order to protect their family and family life. This is so stated, notwithstanding that the family and family life which gays and lesbians are capable of establishing with their foreign national same-sex partners are in all significant respects indistinguishable from those of spouses, and in human terms as important to gay and lesbian same-sex partners as they are to spouses. So in my respectful submission, the reasoning and the analysis is equally apt in the present appeal. Obviously the context is different, it's to do with security of tenure. He continues, the message and impact are clear. Section 10 of the Constitution recognises and guarantees that everyone has inherent dignity and the right to have their dignity respected and protected. The message is that gays and lesbians lack the inherent humanity to have their families and family lives in such same-sex relationships respected or protected. It serves in addition to perpetuate and reinforce existing prejudices and stereotypes. The impact constitutes a crass, blunt, cruel, and serious invasion of their dignity. The discrimination based on sexual orientation is severe because no concern, let alone anything approaching equal concern, is shown for the particular sexual orientation of gays and lesbians. And then he turns to justification, and particularly the argument, very similar to what the argument is in this case, made by the minister, that it was important to protect the traditional institution of marriage. See the last 3 lines of paragraph 55. It would be subject to two major reservations. In the first place, protecting the traditional institution of marriage as recognised by law may not be done in a way which unjustifiably limits the constitutional rights of partners in a permanent same-sex life partnership. In the second place, there is no rational connection between the exclusion of same-sex life partners from the benefits under section 25(5) and the government interest sought to be achieved, namely the protection of families and the family life of heterosexual spouses. No conceivable way was suggested, nor can I think of any, whereby the appropriate extension of the section 25(5) benefits to same-sex life partners could negatively affect such protection. A similar argument has been roundly rejected by the Canadian Supreme Court, that's M and H, in footnote 75. which court has also stressed correctly, in my view, that concern for the protection of same-sex partnerships does in no way imply the disparagement of the traditional institution of marriage. I respectfully adopt that reasoning. And lastly, in this judgment, can I invite attention to page 58, paragraph 59. At this stage of the judgment, Justice Ackerman is doing the balancing exercise under justification. So clearly it has to be done. There is no interest, he says, on the other side that enters the balancing process. It is true, as previously stated, that the protection of family and family life in conventional spousal relationships is an important governmental objective. But the extent to which this could be done would in no way be limited or affected if same-sex life partners were appropriately included under the protection of Section 25(5). There is, in my view, no justification for the limitation in the present case, and it follows that the provisions are inconsistent with the Constitution and invalid. And then the court concerned continued to deal with the question of remedy. My lords and ladies, the reasoning and analysis was adopted by the Constitutional Court of South Africa in a subsequent case concerned with judicial pensions, a case called Satchwell, which is to be found in volume 6 at tab 64. And it's fair to observe that the acting Chief Justice in Gibraltar said in my favour that he thought the reasoning in Satchwell was on all fours with the present case, and that if the South African case law should be followed, then I should succeed. Of course, he then went on to hold that it should not be followed because he should not outrun Strasbourg. Volume 6, tab 64, and the principal judgment this time is given by Justice Badala, and you can see the factual background is set out at page 3, at paragraph 3, and in particular that there were provisions in the legislation governing judicial pensions which, for present purposes, stated that the survivor of a marriage could continue to enjoy certain pension rights if the judicial officer died. You can see that at page 5, at paragraph 7. It was sections 8 and 9 of that Act. And I would just emphasise on page 3, at paragraph 4, line 3 of paragraph 4, although not married, and I emphasise the words in brackets, in terms of South African law, they are unable to enter into a valid marriage. So that's exactly the same legal position as in Gibraltar. At page 6, Justice Madala turns to the constitutional issue and states, at issue in this case is the question whether the claim by the applicant that Ms. Carnelli should be entitled to the benefits enjoyed by the spouses of judges under the Act should be sustained. The Act restricts the provision of certain benefits to spouses only. There is no definition of the word spouse in the provisions under attack. In the circumstances, the ordinary wording of the provisions must be taken to refer to a party to a marriage that is recognised as valid in law and not beyond that. And it cites the case we've just been looking at. It cannot be read to include a same-sex partner. And then in the last sentence, it's noted that accordingly a number of relationships are excluded, such as same-sex partnerships and permanent life partnerships between unmarried heterosexual cohabitants. The legislation has effectively excluded all those in relationships other than heterosexual marriages. The question that arises is whether to the extent that, can I emphasise that phrase, to the extent that the Act restricts benefits to spouses and does not afford them to same-sex life partners, it is inconsistent with the Constitution. So again, they're looking at the impact on this subgroup, acknowledging that there may be different legal issues in other cases to do with other subgroups.
Restricts doesn't seem to be the right word. Confers benefits on
yes,
spouses.
Yes, my lord is right. Can I pick up the citation, please, at page 10? because this is making very much our point based on Flimenos. At page 10, paragraph 16, the judge says, same-sex partners cannot be lumped together with unmarried heterosexual partners without further ado. The latter have chosen to stay as cohabiting partners for a variety of reasons which are unnecessary to traverse here, without marrying, although generally there is no legal obstacle to their doing so. The former cannot enter into a valid marriage. In my view, it is unnecessary to consider the position of heterosexual partners in this case.
That's exactly your position.
I respectfully adopt that reasoning and commend it to the board. And then Justice Madala turned at page 11 in the middle there to the fundamental rights affected by the challenge provisions. And it's right to note at page 12 the text of section 9, the equality clause in the Constitution of South Africa. Now, of course, it's not exactly the same text as in Gibraltar, but I would submit that it is materially the same equality provision. Again, it's freestanding, and this time it does expressly prohibit discrimination on grounds of sexual orientation. It does have a slight gloss on it, if I can put it that way, that subsection 5 requires you to establish that it's unfair discrimination. That's not a concept that we have, at least in Gibraltar law. And then the analysis that the court should adopt was set out in an earlier decision called Harkson and Lane, see paragraph 20 of this judgment. I won't read it all out, but can I just summarise it by saying that it's similar to the kind of analysis that the European Court and the courts of this country do under the Human Rights Act. Is there discrimination? And there they also have to ask under B, is it unfair? I don't think we have to do that. But then they go on to consider justification at letter C. And at 21, paragraph 21, on the next page, the judge says, applying the Harkson test to the facts of the present case, it becomes clear that the denial of benefits to same-sex partners while affording them to married judges is, in effect, may I emphasise that phrase, in effect, a differentiation on the grounds of sexual orientation. Now, I respectfully adopt that reasoning because, of course, it supports my submission so far, picking up that language from the Human Rights Committee general comment about effect, not purpose, and that it doesn't matter that there may also be other subgroups who are also excluded, because you have to ask, in each case, is it justified? At 23, on the next page, Justice Madala states, inasmuch as the provision in question afford benefits to spouses but not to same-sex partners, they constitute unfair discrimination. So they get over that hurdle. And then he turns to justification at page 16 in a very short passage, paragraph 26. The question here is whether the challenge provisions, having been found to be inconsistent with the Constitution, can nevertheless be saved by the limitation clause. And then the limitation clause is section 36. It's a bit like section 1 of the Canadian Charter. It's a general limitation clause. The respondents who bear the onus of establishing that said provisions are reasonable and justifiable in an open and democratic society did not seek to justify such discrimination. That may have been partly because of the reasoning in the earlier case we looked at. In any event, the conclusion then is, and the court endorses the concession, the discrimination was unjustifiable.
Is there in practice any difference in this jurisdiction between showing that it's fair and showing that it's justified? I would have thought in practice two are almost the same.
I have difficulty in understanding what lies behind that conceptual distinction. It appears to be there in the structure of the South African provision and its case law. Whatever its exact delineation may be, I would respectfully suggest that this board doesn't need to be concerned with that problem.
Can you help me with the practical effect of your submissions? Lots and lots and lots of heterosexual couples are in permanent intimate relationships,
Yes.
but do not wish to enter into a formal contract.
Yes.
Lots and lots of homosexual couples are in intimate and permanent relationships.
Yes.
Do I take it from your submission that the Housing Authority is going to ask that latter category, would you enter into a contract akin to marriage if you could? Because most people's reaction would be, mind your own business.
My Lord, no. And the consequence would be very much the same as in the South African cases, and indeed in Gaydan, where you effectively look for the qualities of a permanent same-sex life partnership, but without asking those further intrusive questions. Can I show your Lordship?
So they're better off than the people, the heterosexual people.
In principle, on one view, it can be said that they're better off, but the analysis which supports that is that the state has chosen to allow heterosexual couples to marry. At least there's no legal obstacle to that exercise of choice, and the state has chosen to impose a legal obstacle in the way of same-sex partnerships.
Yes.
Now, what the position would be if you had a different kind of legal system, and now some jurisdictions around the world are in this position, where either you have civil partnerships or civil unions in New Zealand, or you have the right to marry in some states of the USA and in Canada now. In South Africa, subsequently, they said there is a constitutional right to marry. That was a case called Fourie. What the argument would be if then a same-sex partnership chose not to take that right up is a difficult question. But, my Lord, I say that we're exactly where South Africa was in about 2002, where there was no constitutional right to marry at that point. And as we'll see, can I just show you, Lordship, the remedy granted? It's at page 21 in this judgment. And they make a declaration at paragraph 44, 2.1. With effect from the date of this order, it is declared that the omission from sections 8 and 9 of the Act, after the word spouse, of the words or partner in a permanent same-sex life partnership in which the partners have undertaken reciprocal duties of support is inconsistent with the Constitution. And then they read in those words at 2.2 as though the following words appear after the word spouse. Now, it's not a million miles away from what the effect in practice was of the decision of their Lordship's House in Gaydan, in the sense that after the word spouse in the Rent Act, there then had to be read in certain words, which would not necessarily include anyone who was gay. For example, somebody who just had a one-night stand, as transient relationships, as my lady put it. So the law is well capable, I would submit, of formulating what the defined category should be and render their equal treatment without necessarily going into those sorts of intrusive questions.
But I don't quite understand why you regard that as intrusive. Most people who want to get married are very happy to say so. But they tend to have a large party and announce it with, with rings and so on. That is because what they want to do is to enter into a public, permanent, legally recognised status.
Exactly.
That's what they want.
Exactly.
That's why people enter civil partnerships, because they want to do something public to show to the world.
And something which is recognised by the state.
So why anybody should regard that as an intrusive question? Of course, if the answer is no, but that may be the category that you want to get at.
Well, I see the point.
Your point is that they would like to get married, but they can't.
Yes, that's the point. That's as far as I need to go in this case, my lord. All I observe is that when it came to granting a remedy, the South African court was well capable of defining the category of beneficiaries of its judgment, but without having to impose that condition as well.
In this case, is there any evidence in relation to that hypothetical question?
Only this, my lord, that my client did seek advice from both Spain and England about the possibility of...
Yes.
Your lordship may know in Spain you now have a right to marry,
Yes.
but was told that because of residence issues, she couldn't contract either of those relationships. I would suggest that that's powerful evidence of her desire, should the choice be available.
Anyway, if that were the correct consideration or even the determinative factor, it's not one which has been taken into account in making the decision.
Indeed.
Both the judges in the Court of Appeal in Gibraltar made the point, in fact they both said it was an obvious point, that the application of what they describe as a bright line policy in relation to applications of joint tenancies would assist those responsible, and it would mean that the Housing Allocation Committee did not need to investigate the factual basis of every application.
Yes.
Now, if the relevant question were to be, would you enter into a civil partnership if it were available? If the answer to that question dictated whether or not there was going to be a joint tenancy, then the answer would be yes in pretty well every case. And has that to be accepted on its face?
Well, my lord, if one were in that hypothetical situation, that might well have to be explored. My submission would be that unless there's evidence to disbelieve the good faith of those making the statement, that it does have to be accepted. But we're at an earlier stage of the problem, unfortunately. The point about bright lines, however, can I just pick that up, my lord, is this, that similar observations as were made in this case below could have been made in Gaydon. There may well be, if you are to extend rights which extend beyond marriage or even opposite-sex partnerships, there may well be factual questions on occasion. The way in which public law deals with that is in the traditional way. But if a factual question arises, first of all, it's got to be dealt with. Secondly, it's got to be dealt with on evidence. And thirdly, it's got to be dealt with fairly. And ultimately, there's a possibility of judicial review by a court if the public authority acts unfairly or on no evidence or something. But no one is suggesting that it's not open to the state to have some criteria of limitation. For example, to distinguish between the transient and the permanent relationship. But no one is either disputing, in my case, my client is in a permanent, stable relationship. Can I give references to two further South African cases without taking time now? Because they concern slightly different issues. First is J, which is volume 6 at tab 67. And it's only paragraph 19, because there the court again made the point that it was not necessary to include heterosexual unmarried couples in the court's order, which was extending rights to same-sex partnerships. And forgive me, although I know that there are time constraints, I will, if I may, go to the last South African case, which is Fourie, which is in volume 6 at tab 73. Not because of the legal issue in the case, because it concerns a different question, which we don't have to address today, which is whether same-sex partners have a constitutional right to marry. Now, in South Africa, it's been held in company with Canada and some American states that there is a constitutional right to marry. But I go to the judgment of Justice Sachs more for, if I may say so, its eloquent statement of fundamental values. And can I invite attention to paragraph 60 on page 38, where Justice Sachs, again giving the main judgment, says, a democratic, universalistic, caring and aspirationally egalitarian society embraces everyone and accepts people for who they are. To penalise people for being who and what they are is profoundly disrespectful of the human personality and violatory of equality. Equality means equal concern and respect across difference. It does not presuppose the elimination or suppression of difference. Respect for human rights requires the affirmation of self, not the denial of self. Equality, therefore, does not imply a levelling or homogenisation of behaviour, or extolling one form as supreme and another as inferior, but an acknowledgement and acceptance of difference. At the very least, it affirms that difference should not be the basis for exclusion, marginalisation and stigma. And I particularly adopt that last sentence because in the present context, in effect, Gibraltar adopts the difference, the legal obstacle to marriage for same-sex couples, as the basis for their exclusion from security of tenure. And also I invite attention to the last part of page 40, which is the end of paragraph 61. Last 5 lines. In the words of the preamble, South Africa belongs to all who live in it, united in diversity. What is at stake in this case, then, is how to respond to legal arrangements of great social significance under which same-sex couples are made to feel like outsiders who do not fully belong in the universe of equals. 62, just the first 2 lines, if I may. These may seem purely abstract statements, yet the impact of the legal void in which same-sex couples are compelled to live is real, intense and extensive. And I would respectfully submit that that is also true of my clients in Gibraltar. And finally, the only other passage is in paragraph 74 on page 48. It's the end of paragraph 74. It's a point that my lady and others in their lordship's house have made, and it finds an echo here in South Africa. End of paragraph 74. The fact that the law today embodies conventional majoritarian views in no way mitigates its discriminatory impact. Again, that word impact. It is precisely those groups that cannot count on popular support and strong representation in the legislature that have a claim to vindicate their fundamental rights through application of the Bill of Rights. My Lords, Lady, I said that I would return to Corton. Of course, I acknowledge that Corton, on the face of it, is an authority against me. And it's a recent authority in the Court of Human Rights. It's to be found in volume 4 at tab 50. And it may also be helpful if the board has, alongside that, our printed case at paragraph 53. At paragraph 53. This was a case in which UK tax law conferred certain reliefs to married couples, and the person concerned was in a same-sex relationship, but before the Civil Partnership Act had come into force. So obviously he couldn't take advantage of that. And the burden of his complaint was that when it comes to the tax situation, particularly inheritance tax, that he couldn't take advantage of the benefit in tax law which would ensue if he had been married. And what we say in our printed case about this, which I would like to amplify slightly, is first that it concerned Article 1 of the first protocol, in respect of which the European Court of Human Rights provides a particularly wide margin of appreciation, whereas this case is concerned with discrimination on a ground which generally requires very weighty justification. And we've given a reference to Stetch, which I don't need to go to. Secondly, we say that the Civil Partnership Act 2004 had come into effect between the date of the discrimination alleged and this admissibility decision, thus remedying the discrimination from the date of implementation. And thirdly, in any event, we say that it's inconsistent with the approach to discrimination in Thlimenos and in DH, and ought not to be followed if the board regrettably concludes that otherwise it is on all fours with my case. Nevertheless, I would make two supplementary submissions. The next point is that the present case, as I've said many times, arises under the Constitution, not under the ECHR as such. And the last is one that I would like to amplify a little, that tax is a field where there is a network of financial rights, duties, reliefs and allowances, which means that it is difficult to pull at one strand without tearing the entire fabric apart. But just because it is sometimes justified to distinguish between married couples and others does not lead to the conclusion that it is always justified. Everything depends on context. The exercise of justification has to be gone through. Sometimes that line will not be justified, as in re G. And it cannot be right that a line drawn at marriage is always justified, however severe and unnecessary the impact on same-sex couples. And I've given the example of public employment. Suppose today jobs in the armed forces were to be restricted to married couples to the exclusion necessarily of same-sex partners. We would submit that that would be inconsistent with the right to equal treatment. And that's supported to some extent by Smith and Grady. Can I give the reference without going to it? Smith is at supplementary volume 7, tab 82, paragraphs 90 to 105. 90 to 105. Lastly, subject to questions from the board, what I would propose to do now is briefly to address you on our critique of the reasoning of the Court of Appeal in the present case, and in particular the 6 reasons which were given by Sir Paul Kennedy, giving the main opinion for the majority. And they're to be found in volume 1 of the record at pages 194 and 195. At the bottom of page 194, Sir Paul Kennedy stated, 1. Marriage is a status which states are entitled to recognise, encourage and protect by giving advantages to those who have entered into it. And we would accept that. 2, he said, in one sphere, namely in relation to applications for adoptions, it has been held not to be appropriate to make marriage an essential prerequisite because the priority should be the best interest of the child. Re-G. We accept that so far as it goes, but we wouldn't accept any implication of that proposition that it's only in that context that the state has to justify and will be able to justify. Point 3, he stated, we are not dealing with adoption or the rights of a child. True. And the decisions of the European Court show that again and again preferences given to those who have married have been upheld. For obvious reasons, the cases tend to be concerned with taxation. Well, we've seen a very recent example of that. And the rights of survivors to claim money or property. But the principles are enunciated in such a way that there seems to be no reason why they should not apply to an application for a joint tenancy. Well, my lords, my lady, we take fundamental issue with that second half of that reasoning. I don't repeat what I've said, but essentially I base myself on the fundamental principles in Strasbourg itself, Kana, and so on, coupled with the reasoning in the South African cases and in other comparative jurisdictions. Point 4 he makes is that it's immaterial that the applicant and Ms. Muscat cannot marry, because the policy simply distinguishes between, on the one hand, those who are married, and on the other hand, those who are not, unless they have a child in common. Well, we take fundamental issue with that. We say that that's highly material. See the reasoning, particularly in South Africa, and the Strasbourg principle in Flimenos that you cannot treat in the same way those who are in fact differently situated, and in fact in law differently situated. 5, the policy is not totally inflexible, unlike the statutory requirement under consideration in Re G. Well, that may be, but for all practical purposes, we understand the respondents' cases that they do need a bright line, and the bright line they draw is against all same-sex couples. But even if the factual premise is correct, we ask the question rhetorically, so what? It doesn't affect the analysis we have submitted to this board. And 6thly, it's obvious that the formulation and application of a bright line policy in relation to applications for joint tenancies of government-owned housing assists those responsible for administering a very limited housing stock, which is very much in demand. It does not deprive any individual of his or her right to be considered for tenancy, and it relieves the Housing Allocation Committee of the need to investigate the factual basis of every application for joint tenancy, a task which it is manifestly not equipped to perform, in contrast to a court considering an application for adoption. But there are various elements in that reasoning that I'd like to address. There's this point that it's not appropriate for an administrative body to have to investigate the factual basis. Well, I take fundamental issue with that. In lots and lots of administrative law decision-making, the fact finder, in fact, public law states, the fact finder is the administrative authority. And they have, as I said before, they have to do the exercise, they have to do it on evidence, and they have to do it fairly and lawfully. And they're always subject to judicial review as a last resort. I submit there's no problem with this. Secondly, insofar as bright lines are needed, well, yes, in principle, but you can't just draw them in an impermissible place and discriminate just because you need bright lines. And following Gaydan in this country and following Satchwell in South Africa, again, a bright line had to be drawn. Which same-sex relationships do you protect and which not? And terminology like permanent, stable, intimate may have to be in your formulation. But to say that you'll just give up the task completely because it's difficult is not permissible. And my lords and my lady, on the rest of page 195, Sir Paul said that although my approach is not quite the same as that of the learned judge, it follows that in my judgment the judge was right to decide as he did, after taking into account the decisions of the European Court, that although the policy in question dealt with the right protected by sections 1 and 7 of the Constitution, it did not discriminate against the appellant because the preference which it gave to married couples was a positive preference of a kind which the law regards as acceptable in circumstances such as these, and which did not require further justification. Now, there are, in my submission, 2 ways of reading that, and with respect, but it's not entirely clear which is the right way of reading it. One is that there's no discrimination because these are not in an analogous situation, and therefore there's no need to reach the justification stage. That would appear to be consistent with what Sir Paul had said earlier, where I noted in my submissions that he endorsed Mr. Justice Dudley's finding that the state couldn't proffer justification because it was not in accordance with law. On the other hand, and as I understand it from their printed case, my learned friends will submit that that's the wrong way of looking at it, that in fact what Sir Paul is saying there is that this is justified because the state is permitted to distinguish between married couples and others, and it doesn't require any further justification, whatever that may mean.
In this context, he was really saying there are some factual situations where justification is implicit.
Exactly.
But he does say in circumstances such as these.
Such as these, he does.
So it's not entirely clear.
It's not entirely clear.
Yes.
But if I have to reach the question of justification, I don't shy from dealing with it. It's essentially summarised in paragraph 11 of my outline today. And we say, with respect, the Court of Appeal has simply not subjected this discriminatory treatment to the scrutiny it needs on the fundamental principles. First of all, there's an internal contradiction in the reasoning, because if it's not in accordance with law, they should actually just have said it's not justified, because it's not lawful. But even if that hurdle can be overcome, when you ask, well, what is the rational connection between the means chosen. In other words, the discrimination against same-sex couples. How does that achieve, or help to achieve, the purpose of encouraging heterosexuals to marry each other? I invoke paragraph 143 of my lady's opinion in Gaydan, and the reasoning in the South African cases, that there is no rational connection between the two. And therefore, it's a good way of testing whether you are, just, in a sense, it's an unnecessary side effect of what may be a laudable aim. An unnecessary impact is exactly the kind of thing human rights scrutiny is designed to avoid.
Do you say that the finding that this policy was not in accordance with the law, a finding which was not challenged on appeal and actually adopted on appeal, I think?
Indeed.
Do you say that that's a knockout blow so far as justification is concerned?
Yes, I do. That's one of my submissions,
Yes.
my lord, but obviously covering all my bases, as it were.
Yes, I just wanted to get it in context.
That's one of my submissions, yes. Yes.
But you'd quite like us to look at justification because, of course, it does add a certain flavour to your submissions.
It does. And the last point I make on suggested justification is that this is totally bizarre, frankly. Everyone accepts that there's a limited public housing stock, and the means chosen to achieve the efficient allocation of that housing stock would lead, if the respondents are correct, to 2 flats being taken rather than 1. Because your lordships and ladyship recall that on the facts, what was said to my client was that her partner couldn't apply for joint tenancy, but that she could apply in her own name, and that would be considered on its individual merits. My lords, my lady, the last part of our printed case, part 6, deals with the common law principle of equality. Unless I'm asked to, I don't propose to supplement that in oral submissions. I hope it's clearly set out. Of course, our principal submissions are based upon the constitutional right of equality in the Constitution of Gibraltar. But if we need it, then we also invoke the common law principle of equality. May I just check if there's anything else? I'm grateful to Ms Monaghan, but I think that probably, I hope I've covered what I need to. Obviously, I'll deal with any questions if there are any from the board.
No, thank you very much.
And I'm grateful.
Ms Monaghan, does it follow that you have nothing to...
No, my lord, thank you.
Yeah. We could adjourn now and come back at 1:55 if that would be more convenient. Should we do that?